All right, so let's get a few things straight here because we had a deposition where pretty much the main investigator in this entire case had to be deposed separately, and it's worth bringing up a few items that were in contention and had to be clarified and corrected throughout these proceedings. One, that the probable cause that Santiago Madrid had access to this warehouse to begin with was dated from December 17th, not January 6th. From December 17th to the date that this search warrant was approved is a period of a total of 62 days, which is outside of the statute of limitations. Now, the prosecutors mentioned a bunch of evidence that falls well outside in November and has somehow brought that up. I want that struck from the record. But, at very best here, we have a mistrial because the entire probable cause for this raid was gleaned from a bunch of conjecture and 180p photographs of people from behind, assuming conversations taking place were criminal between my defendants and other individuals not called to court today. It's all conjecture. Just because Winston Walker writes in a notepad that Jose Luis Santana is the right hand man and second in command of the Vagos and tags him in the MDW does not make it so, not without proof, not without criminal culpability in ongoing crimes. You cannot simply assume facts to be evident without anything to back them up. Mr. Santana has a total of 2 criminal charges on his records, none of which have anything to do with drugs or guns or any kind of gang violence whatsoever. As far as this entire city is concerned, he is a model citizen with a few minor charges on his record, which we will be looking to get expunged at another time. But nonetheless, the actual probable cause for the raid is fruit of the poisonous tree, and so everything that follows, another reasonable officer would not have done the same, and it is suspected by the defense that there was an intentional effort to mislead the judge who signed this warrant as to the actual specific date of the probable cause in question. I refer at this time to the unredacted report, which states only in the probable cause that due to a long-term investigation, no date or reference to the photo depicting Santiago Madrid
At this time,
at the
I'll be objecting
warehouse.
to it as facts, not in evidence, because the unredacted search and seizure warrant was not submitted into evidence by defense nor the prosecution.
Cross, can you handle this?
Yeah, it was
Ross.
on the docket that the unredacted forms were being sent to Mr. Braun.
Correct.
They were not submitted into evidence.
For God's sake.
Okay, Mr. Doe, on the docket, when it was motioned and it was approved, they were sent to Mr. Braun as part of evidence, since you already had those pieces of evidence. Continue.
It's not even their fucking case.
So anyway, as it states in the unredacted report, basically the premise is that a long-term investigation, and in this case, in this particular case, long-term investigation is simply a euphemism.
Honestly,
for
we're pretty
evidence
happy, I think.
outside of the
Honestly,
statute.
I think we're pretty happy.
60 days, not 61 days, not 62 days, not 59 days for that matter, but 60 days. Anything outside of that, in the interest of fairness and justice for the citizens of this city and the ability to mount an effective defense, there is a limit of time on any investigation and for the relevance of any pertinent evidence. That is something that is there to safeguard everyone in this courtroom who is accused of a crime. Simply gathering endless evidence that may no longer be relevant is not conducive to effective investigations and fair convictions. So that PC depicting Santiago Madrid entering that warehouse was used after its expiration date to get a search and seizure warrant on the properties owned by Mr. Jose Luis Santana. And as such, they should be considered fruit of the poisonous tree because a reasonable officer in a similar set of circumstances would more than likely find that that evidence was bad.
Yes.
So it cannot be upheld in good faith. Now, on to the matter of who is liable or culpable in a rental agreement. You know, in general terms, a landlord
he's right
is
there.
not responsible for the actions of their tenant unless they are aware of them. And in this city, maybe things are slightly different, but I happen to believe in free enterprise. And if someone owns a property and wishes to profit from said property, they should be protected in some way by the fact that they cannot be fully aware and cannot intrude upon any tenant who may be renting said property, unless it can be proven that they were aware of criminal activities going on and taking place, and unless it can be proven that they were participants thereof. I'm sorry?
Sorry, Braun.
Sorry, Your Honor? What? Oh, okay. You were
Oh
just
my God, he's
asking
got a
me to take
gun!
the shotgun out. Unless it can be proven that Mr. Santana was a participant or aware but indifferent of what Mr. Madrid may have been doing in and around those properties, he cannot be held culpable to the same standard as Mr. Madrid. And as the residential property contained a vehicle containing illegal items, vehicle registered to Mr. Madrid, and as we all know,
I think we're like
how
ish winning, you know what I mean?
residences work as far as key holders. That is consistent with him being the sole occupant, as illegal items were not found in the other contents of the residence, only in the vehicle owned by Mr. Madrid. However, there were illegal contents in the warehouse, which Mr. Madrid would have had access to. As stated by Mr. Madrid, he has a drug problem and is a violent offender who does need several weapons to defend himself and carry out his felonious activities besides this case. Now, as to the matter of those weapons and the weapons trafficking charge on Mr. Madrid, I'm going to call your attention to the People versus Tom Ado, where it was ruled
probably Luke.
upon that a standard must be met to show the probability of distribution. In court today, many questions were asked to witnesses regarding the tenacity of those claims. And as you saw, Lieutenant Espinosa had no answer to any of those questions. Focused only on the transportation of those weapons, was unable to elaborate on the probability that Mr. Madrid was going to distribute those weapons. Now, he did have a large number of weapons on him. He admitted as much. And he was in motion when he was apprehended. That much is true. But there was no elaboration of the probability that those weapons were going to be distributed in any way. Moving on to back to the deposition, which again, it's kind of boring for people watching because you weren't here for that probably. The observations of Winston Walker on this case are laughable. Purely conjecture and assumption rendered as fact to be used as evidence in this case against my clients, along with low resolution photography showing primarily people from behind, with claims that people in conversation were involved in some kind of unspecified criminal conspiracy through vague associations. I think it is absolutely the best indication at how weak the case is, especially against Mr. Santana, that at multiple points during his closing, my opponent mentioned the simple fact that my client, Mr. Santana, was seen driving in his own cousin's car. Is that a crime, ladies and gentlemen? Driving in your blood relative's personally owned vehicle. I certainly hope not. But today it might just be, because that is just about all the people have against my client, Mr. Santana, that directly ties him to any of the charges being alleged against him. Which again, Mr. Madrid, against the advice of counsel today, has admitted to wholesale and taken full responsibility for. And to close, I will say one thing definitively. I have represented many drug offenders in many drug trafficking cases, and they all have one thing in common. They stay getting caught. Most of them are kingpins, cultivators, distributors, street dealers, and enforcers, all in one. There's no way that someone could be deeply involved in the drug business in this city without running into the law repeatedly. So, with that in mind, the judges must consider all the facts, must consider the tenacity of the evidence, and the fact that the premises for this entire case fall outside of statute, but also must consider the testimony of my clients who are not afraid to testify in open court today, and must also consider that Mr. Jose Luis Santana has no indication whatsoever of being a repeat drug offender other than the jotted notes of one very, very presumptuous detective. Thank you.
Woo!
That's my lawyer. That's my lawyer right there, ladies and gentlemen. That's my lawyer right there. That's my lawyer right there.
God.
Hey,
I
man,
want
that was
this
actually
lawyer.
pretty
Oh
good.
my God.
Damn,
All right,
Murphy.
hold on. All right, we're gonna go deliberate.
Thank you.
And we'll be back in a moment.
Not
Wait, we don't
guilty
get
or
a
you're
verdict?
bitch.
We don't get a verdict?
No, we're getting a
Shut up,
verdict. They
Raven.
gotta
No,
go,
on the
think about it.
on the fruit of the poisonous tree thing.
That was good as fuck.
Nah, it's alright.
Well, I did
need to
say
jump.
it should be a
Don, do you wanna
mistrial.
go
They're,
first?
Oh,
they're
yeah,
gonna
I
talk about
agree.
it.
Yo,
Don't worry.
Murphy,
Yeah, yeah.
Santi,
by the way,
I never,
a
I head
detective
popped and lost
that
the keys
actually
to the
raided
the
me
Subaru, so
without
we would have
Fair
it.
telling me about it.
That's alright.
You didn't
I'll
know
just
about
take
that,
whatever
right?
happens,
You
I
never
guess.
even got a raid warrant or a receipt or anything?
Nope.
You need to jump, by the way.
I'm Raymond Frost. And
Okay,
he
we're gonna call
raided
us back
me
in a
with
session.
No raid warrants. And nothing. I wasn't even
that was
due
quick.
to the amount of
he got shit on by the cop.
and
Yeah, you were named in this
the
thing.
information revealed in this court case through the testimony, depositions, and the closing statements from both sides.
Mistrial, guys.
We are going to basically put this courtroom into recess for the next however long it's going to take us to deliberate. We'll get back to you between 24 to 48 hours with the ruling.
Whoa!
Oh.
Oh my
what?
god.
Oh,
Oh,
shit.
okay.
What the
Okay.
hell?
They said we.
It's like good or bad. What the fuck?
I don't know.
Well,
Your Honor,
that's
am
a
I
good
free to
point.
I wanna
am I
know
free to
now.
go about
I
my
wanna know
ways?
now.
Yeah,
I
just
think they're
don't
gonna.
traffic anything.
It's because
No,
of the
I don't
statute of
traffic
limitations.
things anyway. So
Any
no
traffic
traffic.
people?
Don't even traffic stops.
No, no,
I know
traffic-
why.
no
It's
traffic
because
stops.
the statute of limitations.
he
they're gonna
traffic
ask,
me?
You know, the people above can be
Well,
used.
if you're
on-
asking permission, it's not.
yo,
traffic.
is this a big fucking
So,
thing?
yeah.
What the fuck?
That's a first, yeah.
Yo,
We can
Santi.
leave.
guess so.
Santi, I think that's a good sign, honestly.
Yeah, we can
What
leave.
the
yeah.
fuck?
Winston,
Yeah, I've never seen that happen before. I think that's a
What
good sign.
the fuck?
going through the warrant